ready then. Okay, let me, first of all, get appearance for the state.
Matt Storch on behalf of the state of Florida.
Public defender.
Tamara Greer for the Office of the Public Defender, Your Honor.
Okay, thank you all. The first case. Oh, are there any folks who need Spanish interpreters?
Yes, Your Honor.
Okay. Let me call the interpreter.
Hello?
Hello, do we have the Spanish interpreter?
This is the Spanish interpreter, Your Honor, Dalia Romero.
I'm sorry, could you speak up a little bit? I had trouble hearing you.
This is the Spanish interpreter, but are you connecting through the BRI? Through the system?
I can't hear you. Are you able to speak up?
Are you connecting through the BRI, Your Honor? Through the system?
Do you mean the headphones or, I don't know what you mean by BRI.
The system were on demand. I'm sorry, I called directly. I didn't know if you had finished with Osceola, if we have some cases for Spanish.
Oh, okay. Yeah, no, so we finished with Osceola. We're now on to Orange.
Okay, great. So I'll wait for you to call me on the system.
Okay, and is this the same interpreter? Were you sworn in previously?
Yes, Your Honor.
Okay, thank you very much. I apologize for that. We're going to start with the cases that need an interpreter then.
No problem.
Do we have, is that Mr. Domingo Lopez?
No, Your Honor. Are you able to call me the same way you did earlier when we did Osceola?
Okay.
Are you able to call me the same way as when we did Osceola, please?
Okay, 1 second. This works.
Perfect. This is the Spanish interpreter, Your Honor.
Okay,
And I will connect now to the podium so he can hear me on the headset.
okay, great.
You can hear the interpreter, Your Honor. Dalia
great.
Romero, State Certified Spanish Interpreter.
Is this Aiden Domingo Lopez?
¿Usted es Aiden Domingo Lopez? Yes.
Okay, welcome, Mr. Domingo Lopez. You are charged with aggravated battery on a pregnant person, tampering with witness to hinder, and domestic battery. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with counsel, and if you can't afford counsel, the public defender's office may be appointed to represent you. Would you like the public defender's office appointed at this time?
Sí.
Yes.
Okay, I'll appoint the public defender. I do find probable cause, and do we have the victim here?
Your Honor, she needs a Spanish interpreter to the victim.
Okay, and we have the victim here. My understanding is that she will need a Spanish interpreter as well.
Okay, Your Honor. Then I will proceed over the loudspeaker.
Okay. Okay, ma'am, can you let us know your name?
Señora, ¿nos puede decir su nombre completo?
Gladys Verónica Pérez Pérez.
Repita, por favor.
Gladys Verónica Pérez Pérez.
Gladys Verónica Perez Perez.
Okay, and I'm going to swear you in. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Levante su mano derecha para prestar juramento, por favor. ¿Usted jura o afirma que va a decir la verdad, toda la verdad y nada más que la verdad ante Dios?
Sí.
Yes.
Okay, and what is it that you would like the court to know?
¿Qué es lo que usted quiere decirle al juez?
¿Cómo se llama? Yo quiero decirle a él que no lo puedo, voy a tirar el cargo que le dije ayer a los policías porque es que estaba pensando, no puedo dar a luz así yo sola tengo un bebé de 8 meses y tengo otro bebé de 3 meses de embarazo. Y entonces, ¿cómo se llama? No sé si se puede retirar el cargo encima de él, pero que él, que ya no haga lo mismo que hizo conmigo, que ya no me golpee y que me respete. Eso es lo que yo quiero.
Your Honor, the interpreter is going to ask for clarification. Señora, usted dice que tiene 8 meses de embarazo y que tiene otro
No.
bebé de ¿cuánto tiempo?
No, yo tengo un bebé de casi ya va a cumplir 1 año, porque solo falta 2 meses. Y yo tengo 3 meses de embarazo.
Okay, un momento. I want to tell him, I want to withdraw the charges because I cannot have this baby without him. I do have another baby at home who's 8 months old and I am 3 months pregnant, but I do not want the same thing to happen again. I do not want him to hit me again and I want him to respect me.
Okay, has anything like this happened before?
¿Algo así ha ocurrido anteriormente?
No, porque antes todo estaba bien. Fue cuando yo reclamé a él que él estaba hablando con otra mujer o se estaba viendo con otra mujer. Y entonces yo le pregunté que por qué hacía eso y entonces él se alteró y me empezó a gritar, a golpearme.
No, because everything was fine before, but I questioned him because he was talking or seeing another woman, and that's when he got upset and he started to yell at me and hit me.
Okay, are you in fear of your safety if you were to continue to be around Mr. Domingo Lopez?
¿Usted teme por su seguridad si usted estuviera alrededor del señor Domingo López?
No, yo ya lo conozco, no creo que... No.
No, I already know him. I don't think so. No.
Okay, I'll allow the parties to ask follow-up questions. State?
No follow-up questions from the state.
Okay, defense?
No follow-up questions, Your Honor.
Ni el fiscal ni el abogado de defensa tienen preguntas.
Okay.
Okay.
Okay, let me ask just one more question. If there were another incident, would you have any fear or hesitation about calling 911?
Si ocurriera otro incidente en el futuro, señora, ¿usted tendría temor o miedo en llamar al 911?
No.
No.
Okay, thank you very much, ma'am. All right,
Gracias, señora.
I'll hear from the parties. Defense?
Your Honor, we would just ask for a reasonable bond with or without PTR and a no hostile contact.
Su señoría, estamos pidiendo una fianza razonable con o sin libertad provisional y que se le permita tener contacto, pero que no sea hostil.
Does Mr. Domingo Lopez qualify for?
Your Honor, we didn't qualify him, but I am putting the recommendation of pretrial release. He has no prior history. The victim is present. Currently, he's employed part-time, so if it's possible to do the PTR.
He does.
If you're given no hostile, I'm recommending a pretrial release. He has no prior history, Your Honor.
Okay, let me hear from the state.
No objection, defer to pretrial services and allow pretrial release if the court permits with no hostile contact.
El oficial del programa de libertad preventiva ha dicho que no tiene antecedentes, que tiene un trabajo a medio tiempo y que están recomendando que se le permita salir bajo el programa de libertad preventiva y el fiscal está de acuerdo.
Okay, here's what I'm going to do. I'll set bond on count 1 at $1,000. Set the bond on count 2 at $500, and the bond on count 3, $250. That's with PTR, and I'll order a condition of no hostile contact. So,
Bien, esto es lo siguiente lo que el juez va a hacer. En el primer cargo va a darle una fianza de $1,000, en la segunda causa 500, en la tercera causa 250. No puede tener contacto hostil con condiciones de libertad preventiva.
and also, if Mr. Domingo Lopez has any weapons or firearms, they shall be surrendered to law enforcement.
También si el señor Domingo López tiene algún tipo de arma de fuego, una vez salga, tiene que entregarla a las autoridades en menos de 24 horas.
Okay, thank you very much, and that concludes your initial appearance, sir.
Gracias. Eso concluye su primera comparecencia, señor.
And I did find probable cause on that.
Y también hallé que había causas.
Okay. Next, do we have Jorge Maniago? Okay. Mr. Maniago, you're charged with driving without a valid license. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with counsel. And if you can't afford counsel, the public defender's office may be appointed to represent you. And it appears to me from the affidavit that we have that you do not qualify for the public defender.
I'm sorry, Your Honor. He does or he does not?
Does not. So, and does Mr. Maniago qualify for pretrial release?
No, Your Honor, we didn't qualify Mr. Jorge for our pretrial release. He has an active warrant out of Seminole County for failure to appear, which he does have a hold for that, Your Honor. He was given a $5,000 bond. He didn't give us any information. He wasn't able to answer any questions that was asked. So we didn't qualify Mr. Jorge for pretrial release.
Okay, then for this case, I do find probable cause, and I will set bond at $500. Thank you very much, sir. That concludes your initial appearance.
Thank you, Your Honor.
Okay, next we have Mr. Tavares Flory.
Your Honor, he's medical.
I'm sorry?
He's medical.
He's not here.
Oh, medical.
He's not
Okay.
here, Your Honor.
So then I'll roll that, I'll reset that initial appearance for
Okay.
medical. And is this Mr. Zabaluali?
Yes, sir.
Okay, give me one moment. I think we have Cesar Zabaluali. Mr. Zabaluali, you have been charged with possession of heroin, possession of drug paraphernalia, and petite theft. You have the right to remain silent, and anything you say may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Sí, señor.
Yes, sir.
Okay, I'll appoint the public defender. And I do find probable cause. I'll set bond at $1,000 on count 1, $500 on count 2, $250 on count 3, and that's with the condition that there shall be no possession or use of alcohol or drugs without a prescription. Okay, that was one case. Okay, so that was case number 2021 CF 013267. In addition to that, there's case 2021 CT 003874. In that case, Mr. Zabaluali, you're charged with failure to appear on account of driving while a license was suspended or revoked with knowledge. As the same directions apply as previously given, would you like the public defender appointed on this case as well?
Yes. Sí, señor.
Yes, sir.
Okay, I'll appoint the public defender. And I do find probable cause. On the failure to appear count, I'll direct that Mr. Zabaluali remain held until he can appear in front of the presiding judge. Next case for Mr. Zabaluali, case number 2020 CF 4767. In that case, Mr. Zabaluali were charged with the violation of probation for possession of with the underlying charge of possession of a controlled substance, violation of probation with the underlying charge of possession of a firearm by a convicted felon. The same directions that I previously provided remain in effect. Would you like the public defender appointed in this case as well? Public defender?
Yes.
I'll appoint the public defender. I do find probable cause, and I'll direct that Mr. Zabaluali remain held without bond in the case as well.
That on both counts, Your Honor.
On both counts, yes.
Thank you, Your Honor.
Okay, the next case I've got is 2020.
He's done.
I believe it's the same one.
Your Honor,
Once an obvious.
while we have the interpreter, we have one case where the defendant does not need an interpreter, but the victim does.
Oh, Your Honor, he's
And
out
this
on
is
bond.
Benny Holt.
We're not done with this. He's out on bond.
Oh,
Yeah, he still has some
I
open
was
cases.
looking through, I had another
Yes.
file.
I'm sorry, Your Honor. I didn't have any. I didn't see any others.
Oh, no, it's okay. Okay, and I apologize, we had not concluded there. I see an indication that Mr. Zabaluali is out on bond in case number 2021 CF 6255 and 2021 CF 6256, and the bonds in those cases will be revoked.
Revoked, Your Honor.
Yes,
And set at 0.
correct.
That concludes his initial appearance, Your Honor.
Yes, it does. That concludes your initial appearance, sir.
I never found out. That was the case that I got ROR. Or I never found out.
Okay. You just need to wait and speak to the attorney that's assigned to you. And they'll help you. Okay? Thank you, Your Honor.
Okay, now the case for which we need an interpreter for the victim is which one? Is that Ms. Holt's case?
Yes, Your Honor.
Okay. Thank you very much. Okay, we have Benny Gale Holt. And Ms. Holt, you've been charged with violation of a domestic injunction. You have the right to remain silent, and anything you say may be used against you. You have the right to confer with counsel, and the public defender's office may be appointed if you can't afford counsel. Would you like the public defender's office to represent you?
Yes, yes, sir.
Okay, I'll appoint the public defender to represent you. I've reviewed the materials. I do find probable cause, and my understanding is that we have the alleged victim here, and the victim, I believe, needs a Spanish interpreter. So I'll just ask, sir, can you tell us your name?
Señor, ¿nos puede decir su nombre?
Miguel Osorio.
Miguel Osorio.
Hey, Mr. Osorio, do you swear or affirm that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Señor Osorio, ¿usted jura o afirma que va a decir la verdad, toda la verdad y nada más que la verdad ante Dios?
Sí.
Yes.
Okay, Mr. Osorio, what is it that you'd like the court to know?
Señor Osorio, ¿qué es lo que usted quiere decirle al juez?
Que la señora Benny Holt respete la orden de protección que el juez de la corte me autorizó por 2 años, que vence hasta el en septiembre 23 del 2023.
That Ms. Benny Halls obey and complies with the injunction that the judge authorized for 4 years, which will be expiring for 2 years, which expires in 9/23/23.
Okay, sir, and is this the first alleged violation that's occurred, or there have been prior incidents as well?
Señor, ¿esta es la primera vez que se alega que ella incumplió la orden de alejamiento o han habido otras ocasiones anteriormente?
Pues esta vez fue cuando se llevó a cabo la detención de ella, porque anteriormente sí tuve que llamar a las autoridades para que notificarles que había violado la protección.
Well, this is the one time that she was detained because previously I had called the authorities to inform them that she had violated the injunction order.
Thank you, sir. I'll allow the parties an opportunity to follow up. State,
No further follow-up questions.
defense?
El abogado de la defensa ni el fiscal no tiene ninguna otra pregunta.
Okay, hush. No follow-up, Your Honor.
Thank you very much, sir.
Gracias, señor.
I'll hear from the
Muchas
parties.
gracias.
State,
Con permiso.
Thank you.
Your Honor, we just ask that any conditions include a no contact, and that's electronic as well as in person.
does the state believe that a monetary bond is appropriate?
Yes, Your Honor, no objection to a monetary bond.
Your Honor, we did qualify Ms. Holt for pretrial release, but it will use your discretion. She did have a battery back in where she pled no contest, May 18th of 21, but that was with a different victim.
Okay, let me hear from the defense.
Your Honor, Ms. Holt is on Social Security income, so she has a very low income. She's not going to be able to afford very much. We would ask for ROR with PTR conditions.
Okay, here's what I'm going to do. I'm going to set a monetary bond at $100 with PTR and with a condition that there be no contact, and that would include electronic contact. And let's see. Yes, that is all. With that, That concludes your initial appearance. Thank you very much, ma'am.
Thank you, Your Honor.
Your Honor, is that the last case that the interpreter is needed for?
I'll ask that question.
Thank you.
Oh, just one moment, we're getting situated.
Your Honor, I believe that that's all that requires the interpreter for the day.
Okay, that is it. Thank you very much, Madam Interpreter. We appreciate it.
You're welcome, Your Honor. Have a great day. Thank
You
you.
too. Okay, the next case I have is Philip William Shoppie. Okay, so do we have, is it Philip, is it Shoppie?
Yes.
Okay, Mr. Shoppie, you were charged with burglary of a structure with damage of over $1,000, criminal mischief equal to or over $1,000, and trespass on property after warning. You have the right to remain silent. Anything you say could be used against you. You have the right to confer with counsel, and if you can't afford counsel, the Public Defender's Office will be appointed to represent you. Would you like the Public Defender's Office appointed at this time?
Yes.
I'll appoint the Public Defender. I do find probable cause. I will set bond on count 1 at $3,500. I'll set bond on count 2 at $1,000. I'll set bond on count 3 at $500, and that's with the condition of no return to the scene.
Your Honor, if I may.
Yes.
Your Honor, Mr. Shoppie is on Social Security disability and he is homeless. It is unlikely that he's going to be able to even afford the 10% bond amount if he were given such, and therefore he would be stuck in the jail until such time that he could go to trial. Therefore, defense is asking for a reduced amount of bond at no more than $1,000 apiece and $100 for count 3. And I'm not going to ask for PTR conditions because Mr. Shoppie is homeless, so it may be difficult for him to participate in that.
So the request was 1,000 for count 1, 1,000 for count 2, 100 for count 3?
Yes, Your Honor.
Okay, State?
No objection, Your Honor.
Okay, with that objection, then I'll reduce the bond amounts previously given to $1,000 for count 1, $1,000 for count 2, $100 for count 3, and that is with the condition of no return to the scene.
Thank you, Your Honor.
Your Honor, he also has a reckless driving case.
What was the amount, Judge? I'm sorry.
What happened?
I'm sorry.
Once again, what was the amount?
1,000, 1,000,
There's another case.
And 100.
and 100. Okay, and PTR?
Yes, Your Honor, he has another case for reckless driving as well.
Okay, and then on the second case, which is, that last case was 2021 CF 13278. I'll then move on to case number 21 CT 6806. And Mr. Shoppie, the same admonitions I provided previously remain in effect. And would you like the public defender appointed to represent you in this case as well?
Yes.
I'll appoint the public defender for this case. And I do find probable cause. I found probable cause on the last one as well. For the reckless driving charge, I'll set the bond at $100. And with that, sir, that concludes your initial appearance.
Is
Thank
that
you very
case
much.
number 21 CT 6806?
Yes.
Thank you.
Thank you very much, sir. Good luck to you.
Your Honor.
Okay, the next one I have is Eric Robinson. Okay, we have Eric Robinson. Mr. Robinson, you were charged with sexual battery on a child under 12 by a person who's 18 years or older, and a second count for the same offense. You have the right to remain silent. Anything you say here may be used against you. And you have the right to confer with counsel. If you can't afford counsel, the public defender's office may be appointed to represent you. Would you like the public defender's office appointed at this time? I'll appoint the public defender. I do find probable cause for these two counts. I will direct that Mr. Robinson be held without bond. And with that, sir, that concludes your initial appearance.
This is yours. Sorry, Your Honor.
Not a problem, not a problem. Okay, so do we have Gregory Sproul? Okay, good afternoon, Mr. Sproul. You were charged with disorderly conduct. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with an attorney. If you can't afford an attorney, a lawyer with the public defender's office will be appointed to represent you. Would you like the public defender appointed?
What? I didn't understand.
Do you want a public defender?
Yes, why not?
Okay, I'll appoint the public defender at this time. So I do find probable cause. Does Mr. Sproul qualify for pretrial release?
Your Honor, he does not qualify for pretrial release. With the city ordinances, they usually make a plea offer. I wasn't too sure if, he does have some history though, but we didn't qualify him, Your Honor.
Okay. Well. Okay, if Mr. One moment.
And we also didn't qualify him. He has no community ties, no contacts, Your Honor.
Okay, if Mr. Sproul is so inclined, I would accept a plea with a sentence of 1 day with credit for time served. Is that something Mr. Sproul would be interested in?
Yes.
This is not yours.
Okay, does Mr. Sproul have a plea to offer at this time?
Your Honor, he's accepted the court's offer. Let me just go over the plea form with him very quickly, okay?
Yes.
He's going to hand you a special pen. Officer. Do you have a pen? I don't get it. this time, Mr. Sproul would like to enter a plea of guilty to disorderly conduct and accept the court's offer of an adjudication of guilt with a sentence for 1 day in jail with credit for 1 day in jail.
Okay, Mr. Sproul, did you understand what your attorney just announced to the court?
Yes.
Okay, do you understand that in entering a plea, there will not be a trial in this matter or the presentation of any evidence, and that you will be found guilty of disorderly conduct?
Yes.
And do you understand that you will be sentenced to 1 day with the credit for your time served?
Yes.
Okay, and do you understand that there will be costs of $223 that will need to be paid, and I will give you 6 months to pay those costs?
Yes.
Okay, has anyone promised you anything in exchange for your plea today?
No.
Has anyone threatened, coerced, or forced you into entering into this plea?
No.
Okay, the court finds that the plea is willingly and voluntarily made, and at this point in time, I will impose a sentence of 1 day with credit for time served. I'll adjudicate the defendant guilty, and that is with court costs of $223 that can be paid within 6 months. With that, thank you very much, sir. The court's accepted your plea, and good luck to you.
Thank you, Your Honor.
Okay. Let's see. Okay, do we have Trent Brown?
Yes, sir.
Okay, we have Trent Brown next. Mr. Brown, you've been charged with attempted burglary of an occupied dwelling and with criminal mischief. You have the right to remain silent. Anything you say may be used against you. And just so that we have it, this is for case number 2021 CF 012643. You have the right to confer with counsel. If you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender's office appointed at this time?
Yes, sir.
I'll appoint the public defender's office. I do find probable cause. And do we have the victim here, or has there been any contact with the victim?
No, Your Honor, no contact with the victim, sir.
Okay, let me hear from the defense on conditions of release.
Your Honor, Mr. Brown is fully employed, but his employment's only been the last 2 months with Prefer Materials. His last conviction was in October of 2017 for a trespass. Therefore, Your Honor, we would ask for a reasonable bond set somewhere in the range of $1,000.
Okay, state.
Your Honor, no objection to a reasonable bond being set with conditions including no return to the scene and no contact with the alleged victim.
Okay, then with that, I will set bond on count 1 at $1,000. For count 2, I'll set bond at $250. That will be with conditions of no contact and no return to the scene.
No weapons.
And the residence. Oh, and I'm sorry.
No weapons.
And also, I will also direct that any weapons or firearms must be surrendered to law enforcement. Okay, so with that,
And Your Honor, you said that was no weapons and firearms also, correct?
that is correct.
Okay, thank you.
Your Honor, has there already been bond set in the 21 CF 13315?
Not yet. I'm moving on
Okay.
to that one
I'm
next.
sorry.
No, it's okay. Thank you very much. Next case for Mr. Brown is case number 2021 CF 013315. Mr. Brown, in this case, you've been charged with criminal mischief of up to $200, a second count of criminal mischief for up to $200, burglary of an occupied dwelling, teeth theft, and a second count of burglary of an occupied dwelling. The same instructions and admonitions I provided previously continue to apply. And would you like the public defender's office appointed in this case as well?
Yes.
I'll appoint the public defender's office in this case. I do find probable cause. For this case, I'll set bond on count 1 at $100, bond on count 2 at $100, bond on count 3 at $5,000, bond on count 4 at $100, bond on count 5 at $150. I'll require conditions of no contact with the victim, no return to the scene of the offense, and that any weapons or firearms will need to be surrendered to law enforcement. Thank you, sir. That concludes your initial appearance. Okay, next person I have is Hind Kochen. Okay, and do we have Ms. Kochen? Okay, Ms. Kochen, you're here on a charge for aggravated battery with a motor vehicle. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with an attorney. And if you can't afford an attorney, one will be provided for you. Would you like the public defender's office appointed at this time? I'll appoint the public defender. I do find probable cause, and I see that we have the alleged victim here. Sir, what is your name?
Salman Kochen.
I'm sorry, I couldn't hear you.
Salman Kochen.
Okay. All right, sir, if you would please raise your right hand. And do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, sir, what is it that you'd like the court to know?
Your Honor, we have a 3-year-old baby together, and this is the 3rd time she getting arrested. Every time small things happen and ask me to leave from home.
Can you speak up a little bit? Just move closer to the microphone.
Okay. I have 3-year-old baby with her. I'm not doing any pressing charge unless she's go to doctors. For small things, she cannot control herself. She's attacked physically. Every time little things happen, she asks me to leave from home, which is I'm leaving. Every time I leave, she's follow me.
How often does it occur that Ms. Kochen sort of loses control and does things that...
It's happened it's not more than weeks.
Are you concerned for your safety or the safety of your child?
Yes, Honor.
Okay. So in deciding what conditions to impose, I just want to understand what your views would be. Do you want Ms. Ko-Chen to return to the residence or to remain somewhere else?
No resident somewhere else. I'm here to actually bail out for my 3 years old baby, but I'm not feel comfortable with her same resident.
Okay, would you like to have any contact with Ms. Ko-Chen?
She can contact, but she cannot close the resident.
Okay, so you're fine with her contacting you. You just don't want her living in the same residence.
That's right, Doctor.
Okay, I'm going to allow the lawyers an opportunity to question you as well, but is there anything else that you'd like the court to know?
No, Honor.
Okay, thank you very much. State?
No further follow-up from the state.
Okay, defense?
Sir, are you going to continue to reside in the mutual residence?
I'm sorry, I couldn't understand.
Are you planning to continue residing in the residence?
Yes, ma'am.
So you would want her to reside somewhere else?
Yes.
Do you guys have family locally?
She has a mother living with us right now. And I mean, she has a previous marriage, 2 kids. She has 1 kid with me also, which is totally 3 kids.
Do you guys currently share financial obligations?
She's not working. I have a business I shut down because of coronavirus 1 year ago. I closed my business. Right now, I'm unemployment.
Okay, no further questions, Your Honor.
Okay, let me hear from the defense on conditions of release.
Your Honor, I would ask for ROR with, and I would ask her to be assessed for mental health pretrial release because she indicates to me that she's had some issues with postpartum. And if that is not available, then I would ask for her to be released ROR with pretrial release conditions. As to not living at the residence, this is going to impose an issue with her considering there is no other family locally and she is unemployed. She is basically going to be put on the streets and homeless.
Okay, state.
Your Honor, pursuant to the testimony of the alleged victim, the state would argue for no bond. I think that he presented competent testimony that he's concerned for not only the safety of himself, but also for his minor child, that she doesn't necessarily have anywhere else to go, that she's offended several times in the past, and she presents therefore a danger to the community. The state is not in agreement to the mental health pretrial release at this time, pending further evidence in regards to that. And so that would be the state's position.
Your Honor, may I rebut that?
Yes.
Your Honor, she has no prior convictions. There are prior allegations, but has no criminal history whatsoever.
Okay, does Ms. Ko-Chen qualify for pretrial release?
You do qualify, Your Honor.
Your Honor, and the reason that I give an alternative in there is because sometimes mental health PTR is unable to qualify them due to residential issues and them not being able to get a bed somewhere. And because I've found previously in my experience that mental health PTR helps them if there are issues with anger or mental health issues, all of the above, they help them get set up with different things. However, if they're unable to qualify, I've had judges in the past put the exception in there, mental health PTR, if not qualified, then regular PTR, so that we don't have to come back before the court.
If I just may add to that, also with the mental PTR, she may not qualify just because of the charge itself. And they didn't put a mental health detainer on her, so there may be some discretion there as well, so.
Thank you so much.
So is the state asking for a monetary bond?
The state would argue for no bond, Your Honor, or in the alternative, if the court's inclined to award a monetary bond, then would ask for it to be a reasonable amount that the court deems appropriate based on the testimony of the victim, the nature of the alleged crime, and the history of the parties.
Okay. Here's what I'm going to do. At this point, I'm going to direct Ms. Cochin to be held on no bond. I think these are issues that need to be addressed in more detail in front of the presiding judge.
You're going to set any conditions? Judge? Judge, you're going to set any conditions once she does?
So let me just, but before you go, Ms. Cochin, let me ask the parties whether any additional conditions should be imposed at this time.
Your Honor, defense doesn't think that that's necessary since Your Honor set no bond, and when it goes before the circuit court judge, it's going to be given additional conditions at that time anyways.
State?
The state has no objections to the representations made by counsel to not impose any additional conditions at this initial appearance.
And right, that was my inclination. So we'll no additional conditions at this time. Thank you very much.
Thank you, Your Honor.
Okay, the next case I've got is Michael Cotto. Okay, it's behavioral, so would the state like to, would the defense like to reset this? Or?
Your Honor, if we could reset for 24 hours and see if he would like to participate tomorrow.
Not sure if
I'm sorry, Your Honor. I couldn't understand. She's getting released or she's going to stay?
Oh, at this time, she is not being released. She'll go in front of the presiding judge if she would like conditions of release to be set.
And next going to be, we don't know yet.
Do we have a court date at this point?
No.
There's not a court date at this point. You can contact the court or the state attorney's office if you'd like to see whether there's a date.
Thank you so
set.
much, Your Honor.
Thank you, sir.
29-7.
Let's get back to Michael Cotto. I think the request of the defense was to reset.
Oh, no objection to a reset, Your Honor.
Okay, we'll reset the initial appearance for Mr. Cotto. I have Kasim Edmund. Okay, Mr. Edmund, you were charged with aggravated assault with a firearm and domestic violence, false imprisonment, domestic violence, and domestic battery by strangulation. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, Your Honor.
Okay, I'll appoint the public defender. I do find probable cause in this matter. Understand that we have the victim here. What's your name, ma'am?
Crystal Baglini.
Okay, welcome. If you would, please just raise your right hand, and I'll ask, do you swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, and what is it that you'd like the court to know?
I would like to press charges, and I want no contact with him.
Okay. Okay, and is it correct that you were residing in the same residence as Mr. Edmund?
Yes.
Okay, have incidents like this occurred in the past?
Yes.
Okay, and would you fear for your safety if Mr. Edmund contacted you or returned to the residence?
Absolutely.
Thank you very much, ma'am. I'll allow the state to follow up if you'd like.
Just one question. Oh, and how many prior incidents have there been?
Well, one time I got ran over. Another time, well, there was a previous time with a gun. It wasn't pointed at me this time, but he had it there and he threatened me to use it. And I've been strangulated before while using the toilet. And I hit in the back of the head. So, and he's threatening it to knows where my family lives. Threatening to kill my son.
Thank you. No further follow-up.
Okay, defense?
Your Honor, I couldn't hear the alleged victim. How many prior incidents are you saying that occurred?
At least 4.
4?
At least.
Did you call the police in all those incidents?
No. The one time that I got ran over, there was several witnesses. The police came to my aid, and I ran away from them. And I didn't press charges. I didn't do anything, and I gave him one more chance.
But you've never pressed charges before?
I did not. No.
No further questions, Your Honor.
Okay, let me hear from the defense on conditions of release.
Your Honor, we would ask for a reasonable bond with conditions of release being no return to the residence, no contact with the victim, and somewhere in the ballpark of $1,000 apiece. He's only been working part-time for the last year and a half. He has no felony convictions, no failures to appear. Your Honor, his last conviction was 2 years ago. It was for something similar, but it has been 2 years, and it was misdemeanor.
And Your Honor, he's also on felony probation, so there is a 5-day hold in place where he can't go anywhere for 5 days. We give probation time to have a warrant served if they wish to. So I just want to make sure the court knows that. You're welcome.
Okay, State?
Your Honor, the state would advocate for no bond in this case due to the violent nature of the allegations, the history of the parties, the testimony from the victim, and the defendant's criminal history, which includes a current violation of probation for a felony case, as well as a similar charge in the Orange County system, which wasn't a conviction, but was charged against the defendant. So for those reasons, the state would advocate that the defendant be held on no bond.
Given the nature of the charges and the testimony of the victim, I think that no bond is appropriate in this case. So I'll direct the defendant to be held without bond. And if I haven't said it already, I've found probable cause in this case. So with that, sir, that concludes your initial appearance. And
Your Honor,
thank you.
if I may?
Yes.
Okay. The no bond is on the 3 current charges and has nothing to do other than the court taking it into consideration with the probation, correct?
That's correct. That's on the 3 current charges.
Okay. Just wanted to verify. Thank you, Your Honor.
Not a problem.
Thank you, ma'am.
Your Honor, that's on all 3 counts. No bond. That's the no bond on all 3 counts. Has conditions on the warrant, yes.
Oh, and in the last case, the conditions from the warrant will remain. So there was no contact with the victim, no return to the scene, no weapons or firearms. Okay, and do we have Melissa Graham? Ms. Graham, you have been charged with contempt of court in violation of a no contact order. You have the right to remain silent. Anything you say can be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender's office appointed at this time?
Yes, sir.
Okay, I'll appoint the public defender. I've reviewed the materials. I do find probable cause. And has there been any contact with the victim?
No, Your Honor.
Okay, let me hear from the parties on any requested conditions of release. Defense?
Your Honor, We would ask for a reasonable bond. Ms. Graham has no prior Florida convictions from the paperwork that I have been provided. And she was out on bond and was supposed to have no contact. That's the basis of this case. Therefore, we would ask for PTR conditions. Even though it says she doesn't qualify, I think that PTR would help her to be compliant with the court's directives.
Okay, let me hear from the state.
No objection to council's requests and a reasonable bond being set, along with the pretrial release conditions of no contact with the victim.
Okay, and is Ms. Graham, is she out on bond in another case?
Yes, Your Honor, she's on my bond for the aggravated assault, case 2021 CF 1209680.
Okay. What I will do is I'll revoke the bond in case number 2021 CF 012096 for the current charge.
Revoked and set at 0, Your Honor.
Yes. So the bond from 2021 CF 012096 is set at 0. For the new charge in 2021 CF 013279, I'll set bond at $500 with PTR conditions and a condition of no contact. And no return to the scene of the offense. And with that, that will conclude your initial appearance.
Whatever you can put to your test. Thank you, Your Honor.
Okay. Next, we've got Melvin Hutchins. Mr. Hutchins, you are here on a charge of aggravated assault with a weapon, domestic violence.
What's your name?
Melvin Hutchins.
Yep. So the judge said you're here on an aggravated assault with a weapon, domestic violence, and a battery, dating violence. Your Honor, he may need you to speak up, it sounds like.
Oh, okay. Mr. Hutchins, you're here on a charge of aggravated assault with a weapon, domestic violence, and battery, dating violence. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with counsel, and if you can't afford counsel, the public defender's office may be appointed to represent you. Would you like the public defender's office appointed at this time? Okay, I'll appoint the public defender. I do find probable cause. Has there been any contact with the victim in this case?
No.
Okay, there's been no contact. Let me hear from the parties on conditions of release. Defense?
Your Honor, it looks like he qualifies for PTR, even though he's a high-risk assessment. His last Florida conviction is showing as November 19th of 2019 for petty theft. He does have some prior history, but it doesn't look like, from what I can tell, it doesn't look like anything in Florida that's similar to this. There is some out-of-state history as well, so we would ask for a reasonable bond in the amount of $1,000 on the aggravated assault and $100 on the battery, dating violence.
Okay, State?
No objections to the representations made by counsel and setting a bond at a reasonable amount, including pretrial release conditions of no contact with the alleged victim.
Okay, I will set bond on count 1 at $1,000, count 2 at $100. Those will be with pretrial release conditions. In addition, I will direct that there be no contact with the victim, and if Mr. Hutchins has any weapons or firearms, they shall be surrendered to law enforcement.
Yes, Your Honor. Thank you so much.
Thank you very much, sir.
Thank you, sir.
Right, that's bond and PTR.
What's that?
That's going to be bond and PTR.
Yes, yes, Judge. Okay, next we have Shimonia Wingster. Ms. Wingster, you were charged with aggravated assault with a deadly weapon without intent to kill. You have the right to remain silent. Anything that you say may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the Public Defender's Office will be appointed to represent you. Would you like the Public Defender's Office appointed at this time? Okay, I'll appoint the Public Defender. I do find probable cause. I see that we have the alleged victim here. And sir, what is your name?
Victoria Wingster.
Okay, welcome. If you would, please raise your right hand, and I'll ask, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, what is it that you'd like the court to know?
That it wasn't assault with a deadly weapon. She never assaulted me. She beat up a car that is her car.
Okay. One moment. Let me ask, have there been any prior incidents of this sort or incidents that concerned you for your safety?
No, sir.
If Ms. Wingster were to have contact with you or return to the home, is that something that would concern you?
No, sir.
If anything did come up that concerned you for your safety, would you have any fear or hesitation about calling law enforcement or 911?
No.
Okay, I'll ask the parties whether they have any follow-up questions. State.
Has anyone forced you or coerced you to come to court today and provide the testimony you just provided?
No.
No further questions.
Okay, defense.
Ms. Wingster, how long have you been with Ms. Wingster?
13 years.
And in that amount of time, have you ever been fearful of her?
No.
Ms. Wingster, do you, at the time of this, an aggravated assault is that you were in fear. Were you in fear that she was going to hurt you?
No, and I told the officers that as well.
No further questions at this time, Your Honor.
Okay, thank you very much. Let me hear from the parties on conditions of release. Defense?
Your Honor, I would actually move to dismiss based on the testimony of the victim. It sounds like there is not probable cause for an aggravated assault. Aggravated assault has to be that there was an assault made with intent to place fear on the victim with a weapon. The testimony taken here today does not indicate that. It indicates that the defendant damaged her own property and that there is no fear by the alleged victim.
Okay, state.
Your Honor, we would object to a court dismissal at this time. I think the allegations in the arrest affidavit, if taken as true, are sufficient to prove the crime of aggravated assault with a deadly weapon, and so the state would object to a court dismissal at the initial appearance, but has no objection to setting a reasonable bond.
Okay, I'll deny the motion to dismiss. Reviewing the four corners of the affidavit, I believe it meets the threshold for probable cause, and I think the kinds of issues that were argued are appropriately addressed at a later stage of the case. So with that, let me hear about conditions of release.
Yes, Your Honor. I would ask for an ROR with pretrial release conditions and no hostile contact, and allow her to return to the scene.
Your Honor, she was qualified for straight pretrial release.
Okay, state.
No objection to either ROR with the conditions laid out by counsel or a straight pretrial release. I'll leave it in the court's discretion.
Okay, so I'll direct pretrial release, and that's with a condition of no hostile contact.
And that's with no monetary, Your Honor?
That's correct.
Thank you, Your Honor.
Okay, thank you very much. Next, we have Jessica Bagnall. Ms. Bagnall, you've been charged with domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
I would like a public defender.
I'll appoint the public defender. I've reviewed the materials. I do find probable cause. Has there been any contact with the victim?
Yes, Your Honor, but the victim was unable to attend court due to having transportation issues.
Did the victim indicate any position?
No, Your Honor.
Okay, let me hear from the parties on conditions of release. Defense?
Your Honor, considering that this is a misdemeanor domestic violence with no Florida history and no out-of-state conditions, or convictions, I'm sorry, and that she qualifies for pretrial release, we would ask for straight pretrial release, no monetary conditions, and no hostile contact.
Okay, State.
No objections to the requests made by counsel.
Okay, does Ms. Bagnall reside with Mr. Weldy? And I'll.
She does, Your Honor. Therefore, we would just ask for no hostile contact.
Okay. And I'm sorry, did Ms. Bagnall qualify for pretrial release?
Yes, Your Honor.
Okay, so what I'm going to do is I'll, defense, give me your requested conditions once more.
Your Honor, we're just asking for straight PTR with no bond requirement and no hostile contact. They do live together, and she does have a child that lives in the residence as well. And therefore, it would be a great imposition if she were to be required to have no contact.
Okay, thank you very much. Under the circumstances, I will direct PTR with no hostile contact, and I'm not going to require a monetary bond.
Thank you, Your Honor.
Thank you very much, ma'am. Okay, welcome. We have next Santoria Brown. Ms. Brown, you're charged with domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender's office appointed at this time?
Yes.
Okay, I'll appoint the public defender's office. I do find probable cause. Has there been any contact with the victim?
Your Honor, the victim stated that he would attend court, but he's not here.
Okay, let me hear from the parties on conditions of release. Defense?
Your Honor, this is a misdemeanor domestic violence case. She has no prior convictions that I show either in Florida or out of state. She indicates to me that they do not live together, so we would ask for straight PTR with no hostile contact unless the state requests otherwise.
A state?
Your Honor, I would just ask for no contact in general. I'm not excluding it to the no hostile contact. Other than that, no objection to pretrial release.
Okay, I'll direct pretrial release, and at this point in time, just since we haven't heard from the victim, I'll direct no contact.
Thank you, Your Honor.
Thank you very much. Okay, the next case I've got is Craig Greene. Hey, Mr. Greene, you are charged with domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yeah.
I'll appoint the public defender. I do find probable cause. Has there been any contact with the victim?
No, Your Honor.
Okay, let me hear from the parties on conditions of release. Defense?
Your Honor, we would ask for a $100 bond without conditions of pretrial release. Your Honor, his last conviction was in October of 2019 for a dualist subsequent offender. On his Florida convictions history, it doesn't show any domestic violence. There are prior arrest history, but those are not convictions. And so therefore, Your Honor, we would just ask for a minimal $100 bond.
Please state.
No objection to the bond requested by counsel, including a no contact order with the victim.
No objections, Your Honor.
Okay, I will set bond at $100 with the condition of no contact.
Okay. Thank you, Judge.
Thank you, sir.
Your Honor.
Good luck to you. Okay, the next case I've got is Michael Jones. Mr. Jones, you're charged with domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you can't afford an attorney, the public defender's office will be appointed to represent you. Would you request appointment of the public defender at this time? Okay, I'll appoint the public defender. Has there been any contact with the victim?
No, Your Honor.
Okay, let me hear from the defense on bond or conditions of release.
Your Honor, we would ask for a $100 bond with no conditions of pretrial release. Your Honor, it looks like his last conviction was in Michigan in 2017 for domestic violence. I don't have any other information from that. It does look like he's got a little bit of out-of-state history. And considering that the victim's not here, it's a misdemeanor domestic violence, we just ask for $100.
Okay, state.
Your Honor, the state would object to the $100 bond. I do think that the defendant's criminal history, while not in Florida, is out of state and is all violence related, or mostly violence related, and he therefore does, in the state's opinion, present a threat or danger to the community. So the state has no objection to a reasonable bond being set in the court's discretion, although the state does feel that $100 is extremely too low for the type of charge in the defendant's criminal history. I would also ask for no contact to be included in whatever conditions are imposed by the court.
Okay, give me one moment. Okay, I'm going to set bond at $500, and I will include a condition of no contact. Thank you, sir. That concludes your initial appearance.
Thank you, Your Honor. Good stuff with you. You're welcome. That way.
Okay. Next, we've got Kayla Keith.
Right here next to me.
Okay, Ms. Keith, you are here on a charge of domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time? Okay, I'll appoint the public defender. I do find probable cause. I see that we have the alleged victim here. Sir, what is your name?
Larry Cruz.
Okay, can you please raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, what is it that you'd like the court to know?
That if I'd have known someone had to be arrested, I never would have called the cops. She had a really bad night, and I just wanted them to separate us, take her to her parents' house or a friend's house. She's never done anything like this before, and you know, it's just not in her character. So if I'd have known this was going to happen, I never would have called the police.
Okay, if Ms. Keith were allowed to come back into contact with you, and let me just ask, do the two of you reside together?
Yes.
Okay, if she were to return to the residence, would you fear for your safety at all?
No, sir.
Okay, I think you said it already, but has anything like this happened before?
No.
Okay, if something did happen that caused you to become concerned for your safety, would you have any hesitation about calling 911 or calling the authorities?
No.
Okay, I'll allow the parties to ask any follow-up questions. State.
Good afternoon. Are you aware of her possessing any weapons?
No.
No further follow-up questions.
Okay, defense?
Sir, are you in fear for your safety with Ms. Keith?
No.
Do you want to remain with, do you want to maintain contact?
Yes.
No further questions, Your Honor.
Okay, thank you very much, sir. I'll hear from the parties on bond or conditions of release. Defense?
Your Honor, considering the testimony given by the alleged victim in this case and the lack of criminal history, she has no criminal history whatsoever that I'm showing here on my form. Therefore, Your Honor, I would just ask for straight ROR with no hostile contact.
State.
No objection, Your Honor.
Okay, I will, in this case, order ROR with the condition of no hostile contact. Thank you very much, ma'am. Good luck to you.
Thank you, Your Honor.
Okay, the next case I've got is Daniel Negro. Okay, welcome. Good afternoon, Mr. Negro. You are here on a charge of domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. And you have the right to confer with counsel. If you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
I'll appoint the public defender. I do find probable cause. Has there been any contact with the victim?
No, Your Honor, we have no available, no number was provided for us, so no contact with the victim.
Okay, let me hear from the parties on bond or conditions of release. Defense?
Your Honor, I would ask for ROR with no contact with the victim. Your Honor, it's a misdemeanor domestic violence case. His last conviction was 17 years ago. They're not great charges, but 17 years is a very long time, and there's no out-of-state history whatsoever.
Okay, State?
Your Honor, the state would just request that a reasonable bond be set by the court, including no condition or conditions of no contact with the victim. Other than that, no objection.
Okay, one moment. Okay, for this one, I'm going to set bond at $250 for conditions. I'm going to direct no contact. I'm going to direct that for the time being, the parties maintain, the separate residences be maintained. If Mr. Negro has any weapons or firearms, they shall be surrendered to law enforcement. If he needs to go back to the residence to obtain possessions, he may do so once with the law enforcement assist.
You're welcome. Thank you, Your Honor.
Okay, thank you very much. Next one I have is Richard Owen. Okay, Mr. Owen, you are here on a charge of domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford counsel, an attorney with the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
I'll appoint the public defender. I do find probable cause in this case. Has there been any contact with the victim?
No, Your Honor.
Okay, let me hear from the defense on bond or conditions of release.
Your Honor, we would ask for a $100 bond and no hostile contact. Your Honor, it looks like his last arrest was in 2011. I'm also showing that there was a Florida arrest for battery domestic violence, same victim, but it's showing last arrest 2011. I don't know if those are the same thing, but other than that, he has no Florida convictions, no out-of-state history. He's got ties to the community. They verified his address through the Orange County property appraiser and his mother.
He did qualify for pretrial release, Your Honor.
Okay, let me hear from the state.
Your Honor, counsel does appear to be correct that the last any type of incident on his record is from 2011. However, it is the same charge that we're here for today, and it is the same victim that we're here for today. So in light of those circumstances, the state would argue that a bond would be appropriate, although $100 is inappropriate, and a more appropriate bond should be set by the court in the court's discretion, with no objection to conditions of pretrial release to include but not be limited to no contact, or I'm sorry, no hostile contact with the victim.
Okay, give me one moment. This one, I'm going to set bond at $250 for the time being. I'm going to direct no contact. I'm going to direct that separate residences be maintained. And if Mr. Owen has any firearms or weapons, they shall be surrendered to law enforcement. He may return to the residence one time with a law enforcement assist.
No PTR, Your Honor.
And that'll also be with conditions of PTR.
For me to take?
Yep. Have a good day, sir. Thank you, Your Honor.
Okay, sir, we have Joseph, is it Sears?
Yes, sir.
Okay, Mr. Sears, you are here on a charge of domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford an attorney, a lawyer from the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, please.
Okay, I'll appoint the public defender. I do find probable cause. I see that we have the alleged victims here. And can you just state your names?
Natalie Sears.
I'm Abby Sears. She's the victim. I'm her mother. She's 17.
Okay, all right. Ms. Sears, could you just raise your hand, your right hand, and do you swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, what is it that you would like the court to know?
That I stand by and press charges on my father for strangling me and having his arms around me.
Has anything like this occurred before?
Personally, to me, no, but I am in fear of my brother, my sister, and my mother.
Okay, have there been any incidents of violence with respect to your mother, your siblings, or other family members?
With my mother, yes, sir.
And what occurred?
Say that one more time, please.
What occurred with your mother?
He's laid hands on my mother multiple times. He's had a gun to her head multiple times. He comes inside the house causing everything. He verbally attacks me every time he's there. It feels like it's a hate passion towards me, honestly.
If your father were to come back in contact with you, return to the residence, would you be in fear of your safety?
Yes, sir, all the way.
Okay, I will allow the parties an opportunity to ask questions as well. State?
Are you aware that your father consumes drugs or alcohol?
I was aware at one point he did.
No further follow-up.
Vince?
How long ago would that have been?
When he got released from prison,
And do you know when that was?
I'm gonna say July 2020.
Are you in fear of your father?
Yes, sir. Yes, ma'am.
Has your father ever done anything to you in the past?
No, ma'am. This was the first time he's ever.
Okay. No further questions, Your Honor.
Thank you very much. Let me hear from the defense on bond or conditions of release.
Your Honor, we're going to ask for a bond set in a reasonable amount set at the discretion of the court with no contact and with the alleged victims and with PTR conditions. Your Honor, he has no out-of-state charges, so he's not a flight risk. He does have an extensive history, which is why we're asking for PTR and a monetary bond amount. I'm not asking for a specific amount due to his extensive history, but it is a misdemeanor domestic violence case. There are 2 active injunctions as well.
Okay, there are 2 active injunctions.
Yes, Your Honor.
There's one with the same victim, one with a different victim, Your Honor.
Okay, State?
Your Honor, well, this is a misdemeanor battery, I think, based on the testimony of the alleged victim and the defendant's extremely extensive criminal history just in Orange County, almost all of which are violent in nature or dangerous in nature, that the defendant clearly poses a risk and danger to the community. And so the state would advocate that the defendant be held on no bond, although acknowledges that that is potentially not an option due to the charges. However, the state does think in the alternative that a bond, if to be set by the court, would be set in a very high amount to exceed. I'm not sure. I mean, potentially $5,000 to $10,000, but we'll leave in the court's discretion. I just think that this defendant does clearly pose a threat to the community and to specifically these 2 people who are here today to represent their positions on this.
Okay, I'll respond.
Just a quick rebuttal, Your Honor. He is entitled to a bond. It is a misdemeanor case. The injunctions actually, he has an injunction the other direction. So I believe that these are family issues, that there may be things going both ways. We ask for a reasonable bond, well below what the state is asking, with pretrial release conditions.
Okay, here's what I'm going to do. In light of the circumstances and the testimony, I think a bond in line with what the state is requesting is appropriate. I do think he is entitled to a monetary bond, though. So I'll set bond at $7,500. That will be with conditions of no contact. Separate residences must be maintained. He may return to the residence one time to obtain his personal effects with a law enforcement assist. If there are any weapons or firearms, they must be surrendered to law enforcement. I'll also include a condition that there shall be no possession or consumption of alcohol or drugs without a prescription, and include PTR conditions as well.
Thank you, Your Honor.
Thank you very much. Okay, and if anyone needs a brief break at any point in time, just raise your hand and let me know. I know we've been going for a while. Okay.
I just need a drink of water.
Okay.
I was going to actually suggest it's saying that this would be maybe an appropriate time for a quick recess. I'm just going to step out and use the restroom if that's okay, Your Honor.
Sure. Why don't we take about 10 minutes? We'll come back at 3:50, just to give everybody an opportunity to
Thank you, Your Honor.
rest. Absolutely. Okay, do we have everybody back that we need?
Yes, Your Honor.
Okay, why don't we bring in Mr. Puring. Okay, we have Alan Puring. Mr. Puring, you've been charged with possession of a counterfeit driver's license, a second count of possession of a counterfeit driver's license, fraud in the use of personal identification information. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time? Okay, I'll appoint the public defender. I do find probable cause, and it appears that Mr. Puring is out on bond in case number 2021 CF 2919. So I'm going to revoke the bond in that case. I will set bond on count 1 at $2,500, on count 2 at $150, and on count 3 at $150. And with that, sir, that concludes your initial appearance. Thank you very much.
Thank you, Your Honor.
Next, we should have Keith Brown. Mr. Brown, you've been charged with... Oh, I'm sorry?
I have Cunningham, Your Honor.
Keith Brown, do you have a booking number, Your Honor? Or
Hold on, Cunningham.
Brown?
Do we have a...
Let me see.
21023605.
Bonded. He
Oh,
bonded,
bonded.
Your Honor.
Okay, that explains that. Okay, we have Noah Cunningham then. Mr. Cunningham, you're here on a charge of giving false name adversely affecting another and fraud in the use of personal identifying information. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender's office appointed at this time?
Yes, sir.
Okay, I'll appoint the public defender. I do find probable cause. And I will set bond at $2,500 on count 1 and $150 on count 2. And with that, sir, that completes your initial appearance. Thank you very much.
Thank you, Your Honor.
Okay, next we should have Wadley Philius. Mr. Philius, you are here on 2 charges for failure to appear. Underlying charges are possession of a controlled substance and possession of drug paraphernalia. I do find probable cause, and I am going to direct that you be held until you can appear in front of the presiding judge. Thank you very much, sir. That will conclude your initial appearance.
Thank you, Your Honor.
Okay, next, we should have Dolce Gomez Benitez. Ms. Gomez Benitez, you are charged with dealing in stolen property and receiving money from a pawnbroker with false verification. You have the right to remain silent. Anything you say here may be used against you. In addition, you have the right to confer with counsel. And if you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll appoint the public defender. I do find probable cause. I'll set bond on count 1 at $1,000. I'll set bond on count 2 at $50, and I will include a condition of no return to the scene of the offense.
Your Honor, we did qualify Ms. Benitez for straight pretrial release.
Okay, I'll hear from the parties on that then. State?
No objection.
Okay, defense?
Your Honor, we would ask for straight pretrial release if there is no monetary bond condition. If we're going to maintain monetary bond, we would ask for no pretrial release.
Okay, give me one moment.
Thank you, Your Honor.
Okay, I will allow straight pretrial release with the condition of no returning to the scene of the offense.
Thank you, Your Honor.
Thank you very much, ma'am. Good luck to you.
Thank you, Your Honor.
Okay, thank you. Next, we should have Javed Iqbal.
No, Your Honor, I have Tiara Jennings.
Okay, I had Mr.
Oh, Perez?
Jennings.
Oh, okay. Sorry, Your Honor.
2102-3606.
Okay,
Bonded.
Bonded out, okay. So then and what about Tiara, is this Tiara Jennings? Okay, what would the parties request as to Ms. Jennings? Defense, Ms. Jennings, Tiara Jennings got an indication that she is behavioral.
yes, Your Honor.
So state?
No objection to a reset.
24 hours reset, see if she's able to participate, Your Honor.
Yeah, no objection.
Okay, we'll do a 24-hour reset then on Ms. Jennings.
Thank you, Your Honor.
Okay, so then we should have Sabrina Perez. Ms. Perez, you are here on a charge of possession of heroin and a charge of possession of drug paraphernalia. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll appoint the public defender. I do find probable cause. It appears that you're out on bond in case number 2021 CF 9008. I will revoke the bond in that case. On the charges in this case, I will set bond at $1,000 on the possession of heroin count, $100 on possession of drug paraphernalia. That will be with the condition that alcohol or drugs not be possessed or consumed without a prescription.
Your Honor, if I may.
Yes.
Well, that was $1,000 on count one and $100 on count two.
Yes.
And that was revoked and set at zero. Would you, on 21 CF 9008?
Yes, 2021 CF 9008 is revoked and set at 0.
Would Your Honor be inclined, Ms. Perez has extenuating circumstances with her family at home. She's got her father.
My father's diagnosed with cancer. My mother has dementia, and I have a 9-year-old I need to take care of.
That's the duty phone. Hang on just one moment.
Yes, Your Honor.
Just give me 1 second. Well, as Judge Buckman,
I know, but you're getting, you've got pieces. I understand.
Okay, great. I will take a look at it in just a moment. Thank you. Okay, I apologize. So the extenuating circumstances.
Her father has stage 4 cancer. Her mother's got dementia. She's got a 9-year-old child at home. I was just asking if the court would be inclined to, instead of revoking and setting at 0, revoke and set a new bond amount in that 21 CF 9008 case.
Your Honor, she does have an open case in Seminole County as well for burglary, conveyance, and petty theft.
What I'm going to do is I'll revoke, and that's an issue that can be taken up with the presiding judge.
Okay.
Presiding judge.
Okay. Your Honor.
I'm sorry? No, let's do a few more, and then I can do it. I've got to we'll get to it. Oh, let me-
Thank you, Your Honor.
Okay, thank you very much. Okay. Should have Kareed Price.
Good morning, Your Honor.
Good morning, good morning. Okay, or good afternoon. Mr. Price, you are here on charges of fleeing or attempting to elude a law enforcement officer with sirens and lights activated, and driving while license was revoked as a habitual offender. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. And if you cannot afford counsel, the Public Defender's Office will be appointed to represent you. Would you like the Public Defender's Office appointed at this time?
Yes, yes, sir.
I'll appoint the Public Defender's Office. It appears that you're out on bond in case number 2021 CF 005874. I'm going to revoke the bond in that case. As to the charges in the current case, which is, and that the bond will be set at 0. As to the charges in the current case, which is 2021 CF 008296, I will, one moment.
Your Honor, I have a driving record if you need to look at his driving history.
Oh, I'm sorry?
I have a driving record for him.
Okay. Okay, so what I'm going to do on the new charges, count 1, I'll set bond at $3,000. For count 2, I'll set bond at $2,500. Okay, with that, sir, that will conclude your initial appearance, and thank you very much.
Good luck to you, sir. Thank you, Your Honor.
Okay, thank you very much. Okay.
Okay.
Thank you, ma'am.
Okay, we should have Angel Rioshoyas here. And so you were charged with petite theft with 2 prior convictions. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. And if you can't afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender's office to be appointed at this time?
Yes, Your Honor.
Okay, I'll appoint the public defender. So it appears that you are out on bond in case number 2021 CF 006572. I'll revoke the bond in that case and set the bond at 0. For the new charge in case number 2021 CF 009685, I'll set bond at $2,500. One moment. And that will be with conditions of no contact with the victim and no return to the scene of the offense. Okay, in addition, on case number 2021 CF 9798. Mr. Rioshoyas, you've also been charged with petite theft with 2 prior convictions. The same instructions I gave you before continue to apply. And would you like the public defender's office appointed in this case as well?
Yes, sir.
I'll appoint the public defender's office. On the charge in this case, I'll set bond at $2,500 with the with conditions of no contact with the victim and no return to the scene of the offense.
May I be heard, Your Honor?
Yes.
Your Honor, in regards to this new case, 2021 CF 9798 and 2021 CF 9685, I'm looking at the warrant arrest affidavits, which indicate on each of them, the original agency case number is a 2020 case number, which would indicate to the defense that he actually did not commit or is alleged to commit these crimes while he was out on bond, but instead he committed them before and was arrested for them later. Therefore, he did not violate the terms and conditions of bond in 21 CF 6572, and we would ask that you not revoke bond in that case.
Okay, State?
No objection to counsel's requests.
Okay, so then I will not revoke bond in 2021 CF 006572 based on the further information provided. Turning back to case number 2021 CF 009798, I've set bond at $2,500 with conditions of no contact with the victim and no return to the scene of the offense. And I think
Thank you, Your Honor.
those are the only ones. Thank you very much, sir.
Your Honor, I'm sorry, I just wanted to go over this real quick. So the case he's out on bond, the offense date was May 18th of 2021. And the 9798 case, the offense date was June 7th. All right, you're correct. I'm sorry.
Thank you very
It
much.
gets confusing after.
Your Honor, I must, and on behalf of Mr. Rio Hoyos, ask that you reduce it down to $1,000 apiece. I understand that you've already ruled, but he's trying to get back to work on Monday.
Thanks, sir.
Okay, State?
No objection, Your Honor.
Okay, then I will reduce bond on both of the cases to $1,000.
Thank you, Your Honor.
Thank you very much, sir. Good luck to you. Okay, give me, you all can bring the next person in. I just need 2 minutes to deal with an emergency warrant.
Yes, Your Honor. They're not as bad as when I have heels on. That's the day that I did it when I was here for hours. I was going to see heels on. I thought I was going to die. I got my heels in there. I already took them off.
She's like, you don't even wear them. Oh, that's just the walk. Yeah. Oh, okay. It's the look, I got you. Yeah, yeah, that's cool.
Fine.
So I can end up having to deal with all of this anyway.
Look, I mean, there's a big difference between like thefts and batteries, bag assaults.
Yeah. Well, we're gonna have a conversation about not taking things that don't belong to us.
Yeah, that's a good combo to have.
But yeah,
You have 42 to 0.
42 to 0? Florida?
Yeah, Florida.
I don't know if we're gonna make it.
Make it where?
To win. I mean, I don't know.
It's over.
That's not this case.
All right, sorry about that. So next, do we have Mr. Turby David? Or- I'm sorry? Behavior. Okay. Let me hear, do the parties have any objection to a 24-hour reset?
No objection, Your Honor.
No objection.
Okay, we'll do a 24-hour reset. Okay, we should have LaShawn Williams. Mr. Williams, you've been charged with grand theft, third degree of motor vehicle. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender's office appointed at this time?
Yes, sir.
Okay, I'll appoint the public defender. I do find probable cause. I will set the bond at $1,000. And that will be with the condition of no contact with the victim. That concludes the initial appearance on that case. That was case number 2021 CF 013313. There is also another, Mr. Williams, there's also a charge of no valid driver's license. The same instructions I previously provided apply, and would you like the public defender appointed on this case as well?
Yes, sir.
Okay, I'll appoint the public defender. I will set bond at $500 on this case. That's 21 CT 6807.
Thank you.
Thank you very much, sir. That'll conclude your initial appearance.
Thank you, Your Honor.
Okay, next we should have Rodney Windsor. Mr. Windsor, you are here on a charge of petite theft with 2 prior convictions. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, Your Honor.
Okay, I'll appoint the public defender. I do find probable cause. It appears that you are out on bond in case number 2021 CF 006897. And I will revoke the bond in that case and set it at 0. With respect to the charges in 2021 CF 013209, I'll set bond at $1,000. That will be with the condition of no return to the scene of the offense. And with that, sir, that concludes your initial appearance, and I hope you have a good day.
Okay.
The next person, Your Honor, she's medical at this Worlds.
Oh, I'm sorry?
Medical, Ms. Worley.
Worlds.
Worlds.
Okay, so Ms. Worrells is medical. Any objection to resetting?
No objection, Your Honor.
No objection.
Okay, we will reset 24 hours. Okay, next person I have is Teresa Ayala.
No, Your Honor, I'm Josiah Titra. Titra?
One moment.
2102-3600.
Bonded.
Bonded, okay. So we should have Josiah Titra. You are here on a charge of no valid driver's license. You have the right to remain silent, and anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll appoint the public defender. I do find probable cause, and it also appears that you are out on bond in case number 2020 CT 000796. So I'll revoke the bond in that case, set it at 0. And for the new charge in case number 21 CT 6804, I'll set bond at $500.
Thank you, Your Honor.
Thank you very much, sir, and best of luck to you. Okay, next we should have Daniel Bright Monroe.
No, Your Honor.
Okay.
Number.
2102-3601.
Bonded.
Fine, okay.
And Your Honor, on Mr. Martin, when we get to that, I do need to make argument.
Okay, is this Mr. Martin?
Yes, Your Honor.
Okay, we should be here with Jacarius Martin. Mr. Martin, you've been charged with possession of cannabis under 20 grams. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. And if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yeah.
Okay, I'll appoint the public defender. And is argument directed to
Arguments directed to bond, Your Honor, and
So I just, so that I will say I do find probable cause, so I'll hear argument.
thank you, Your Honor. Your Honor, it appears that he already was out on bond in 21 MM 583 and 21 MM 4573. However, I'm showing that those cases are competency issues. Therefore, Your Honor, we would ask that you not revoke and set it 0. He may still have competency issues. So we ask that you not revoke those and set this on for bond in a reasonable amount.
Okay, let me hear from the state.
No objection.
Okay, so then there are 2 other cases. I will not revoke the bonds in those cases. For the charge in the current case, which is 2021 MM 007164, I'll set bond at $500. That will be with the condition that Mr. Martin shall not possess or consume alcohol or drugs without a prescription.
You said don't revoke, right?
Don't revoke.
Thank you, Your Honor.
Okay, thank you very much.
Okay.
Okay.
Kelsey, with her practice, she's medical.
Okay, so for Ms. Perez, then we will reset.
I need you to sign this again. I accidentally wrote the wrong name on your other one. And Your Honor, Mr. Cleveland Robinson is actually going to be a plea.
Okay. Okay, we should have Cleveland Robinson here. Mr. Robinson, you are here on charges of trespassing on property after a warning. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford counsel, an attorney with the Public Defender's Office will be appointed to represent you. Would you like the public defender appointed at this time?
You want a public defender? Do you want me to represent you? Do you want me to represent you? Do you want me to be your attorney? Tell him that. Tell him yes.
I need you to say yes, sir, to me.
You see the judge? The judge wants to know if you want me to be your attorney. Yes.
Okay, then I'll appoint the public defender at this time. I do find probable cause for this charge.
Your Honor, the state's already made an offer of adjudication of guilt, no return to the scene with court costs. So credit for time served. If the court would be so inclined. Mr. Robinson is homeless, and it looks like his history is that of a...
I'm inclined to accept that plea. So let me just ask Mr. Robinson, do you understand what your attorney announced to the court in terms of the plea? Okay, and do you understand that in entering a plea, there will not be a trial in this matter or the presentation of any evidence, and that you will be found guilty of trespassing on property after a warning? Okay. And what are court costs? Okay, and court costs in the amount of $273 will be required, that must be paid. I'll allow 6 months to pay that. Do you understand that, sir? Okay, has anyone threatened, coerced, or forced you into entering a plea in this case? Has anyone threatened or forced you to enter into a plea?
Has anybody forced you to do this? Okay.
So the court finds that the plea is willingly and voluntarily made. The court accepts the plea. I will adjudicate Mr. Robinson guilty of the charge of trespass on property after warning. The sentence will be 1 day with credit for time served. Costs of $273 will be required to be paid. Those may be paid over 6 months, and there will be a requirement of no return to the scene of the offense. Oh, well, if it's 2 days, then there'll be credit for 2 days.
Thank you, Your Honor.
Okay, thank you very much, sir. And with that, best of luck to you.
Go home now. You can go home now. Go that way. Thank you so much. Hey, what's your name? Hey, Patrick.
Okay, so we should have Patrick Brumfield. Mr. Brumfield, you are here on a charge of possession of cocaine. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. And if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like me to appoint the public defender at this time?
Yes.
I'll appoint the public defender. I do find probable cause.
Your Honor, this is out of county warrant.
Okay, and because it's an out-of-county warrant, I will direct that you be held until the presiding judge can see you. Thank you very much, sir.
Excuse me, sir.
Be careful what you say.
Do you want to confer with your attorney?
What you need to say to him. I turned your mic off. Let me see your paperwork. One moment, Your Honor, if you may. Beg the court's indulgence. Your Honor, if I may be heard in regards to Mr. Brumfield.
Yes.
Your Honor, what Mr. Brumfield tells me is that this out-of-county warrant is from when he was 18 years old. He is currently 31, you said, sir? Okay. This is a pending warrant. It shows on the Broward County Clerk of Court's website as a case from 2009. Your Honor, I would ask that you set bond in this case, even though it's an out-of-county warrant, and allow him to go take care of this. For the fact that he has not been in any trouble since 2009 says a lot about his character and that he's not a flight risk. If he had been in trouble since then, it would show up and he would have been picked up on it in between now and then. Your Honor, therefore, I believe that there's no reason to think that he's a flight risk or a danger to the community.
Okay, I understand the circumstances, and I need to allow the presiding judge to deal with it. So at this point in time, I'm not going to set bond, and I'll allow the presiding judge to hear any argument.
Okay, thank you, Your Honor. Can I approach?
Yes.
State.
So, next one I have is Patrick D. Bartolomo.
Your Honor, he refused. He refused.
He refused. Okay. For Patrick D. Bartolomo, I'll find that he's waived initial appearance. He is also here on an out-of-county warrant in case number 2019 CF 002718, as well as another out-of-county warrant in case number 2019 CF 002718, and a third out-of-county warrant on case number 2020 CF 000116. And I've got another one, also out-of-county warrant, 2020 CF 00116. Oh, was that the same case? Okay, so that was just the same case twice. On each of those cases, I'll direct that Mr. D. Bartolomo will be held without bond at this time. Okay, next is this Angela Martinez.
Yes, Your Honor.
Okay, Ms. Martinez, you're here on a charge from an out-of-county warrant with the underlying offense, driving with a license suspended, first conviction. You have the right to remain silent in these proceedings. On your out-of-county warrant, I am going to direct that you be held without bond at this time until you can be heard on the warrant.
Your
Thank you.
Honor, on that warrant, they did give her a $2,000 bond.
Oh, well, I'll,
That's, let's double check. I believe it was a $2,000, yes, $2,000 bond, Your Honor.
okay, then I'll maintain the bond on that warrant, which is $2,000.
Thank you, Your Honor.
Okay, thank you very much. Okay, and do we have, is this Erica Nolin? Ms. Nolin, you are here on an out-of-county warrant. The underlying charge is for a violation of probation. You have the right to remain silent during these proceedings. Since this is an out-of-county warrant with an indication of no bond, what I'm going to do is direct that you be held without bond at this time until you can get in front of the presiding judge. Thank you very much.
Do you know how many days they have on this one?
So what will happen, the teletype will be sent, she's in, let me see, Walton County. Let me see what teletype is reading, give me one moment. See if there was a teletype sent. Okay. Confirmed. Let me see. Yeah, they have a, Walton County will be contacting the jail when they'll be picking her up. And that was as of October 8th.
Thank you, Your Honor.
Okay. Do we have anybody else?
Yes, Your Honor. The next gentleman, Brodis Cornelius, he's mental health.
Okay, this is this
He's just not, they don't bring him up.
Cornelius Brodis.
Not only mental health.
Okay.
Okay. So I'm sorry, you indicated, is this Mr. Brodis we're talking about? Cornelius Brodis, is that the next one?
Yes, Your Honor.
Okay, and it's mental health. I'll just ask the parties what they'd like to do. State?
No objection to a reset, I guess.
Your Honor, you can keep resetting it if you'd like. He already has a $500 bond, and he's in mental health, so he's not going to get brought up here. If you want to just set it at the 500 that it already is.
Okay, so for Mr. Brodis, I will, let's see.
Do you have any objections, State?
No objection.
Okay, with respect to Mr. Brodis, then I will stay the bond at $500.
Thank you, Your Honor.
And that will be with the condition of no return to the scene.
Thank you, Your Honor.
Okay, next one I have is Samuel Hunter.
Your Honor, he refused.
Okay, so for Mr. Hunter, then he is charged with violation of probation with the underlying charge of petite theft or $100 or more. I will direct that he be held without bond until he can get in front of the presiding judge.
Thank you, Your Honor.
Okay, how about Robert Washburn? Okay, any issue with resetting until when he gets out of the hospital?
No
State?
objection, Your Honor.
No objection.
Mr. Washburn will be reset. Then, do we have Benjamin Gross? Okay. Mr. Gross, you are here on a charge of violation of probation. The underlying charge is lewd and lascivious indecent assault on a child under 16. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. And if you cannot afford counsel, the public defender's office will be appointed to represent you. Would you like the public defender to be appointed to represent you at this time?
I have a private attorney, sir.
You have a private attorney, okay.
Yes, sir.
Okay, then with that, this is a violation of probation. I will do find probable cause, and I will direct that you be held without bond until you can get in front of the presiding judge. Thank you very much.
And Your Honor, he also has reporting requirements. So once he gets released from jail, he needs to report his current address to DMV and the law enforcement sheriff's office.
I
Orange County.
apologize. Current address meaning my home or here? I'm sorry.
Yeah, when you get released. When you get released, where you're heading to, your
Where I'm
residence.
heading
Yes,
to?
yes.
Okay, I apologize for the
Yes.
question if it was a stupid.
No, I'm sorry.
No stupid questions.
Okay.
Thank you very much, sir. That will
Good luck to you,
conclude
sir.
your initial appearance. Okay, do we have anybody else? That's it.
Hearing none.
All right, so let's